following an appeal filed at the Supreme Court by government entities against the Court of Appeal ruling that declared the Finance Act 2023 unconstitutional. The 7-bench judge panel today concluded the hearing of the petition by 53 petitioners led by Busia Senator Okia Omtata, with the judgment to be issued on notice.
We will resume.
Among issues raised by the judges were questions on whether the Act met the adequate threshold for public participation, with the petitioners arguing it didn't.
The question I'm asking is that a breach of the requirement of public participation when it was not known, or was it a new framework that was introduced to raise the bar? And therefore my question is that unconstitutional, or it is a procedure that was now introduced? Is it a mere infraction because it is agreed there was public participation? It's only that the bar was raised.
Lead counsel for the National Assembly, Issa Mansu, reiterated the position that there had been adequate public participation and that numerous avenues were made available for the same.
The reports of the committees are published and uploaded on the website on what business of the day is coming in at any given time, and so people can follow what is coming in. The Hansard, as my Lady Justice confirmed, is also uploaded. And then there's the audit paper which contains the amendments that have been done and which have been proposed. And then there are the social media handles. Twitter, the National Assembly at KE, that's a Twitter handle. And then there's Parliament of Kenya and Facebook. All this go on concurrently.
On his end, lead counsel for the Attorney General cautioned against upholding the ruling by the Court of Appeal, saying the move was akin to crippling the economy.
The judicature, without condoning breaches of the Constitution, should avoid radical rulings that imperil the stability of the state, which is exactly what the High Court did in this matter. When you defund the state by a single stroke of the pen, you defund the state.
Representing the petitioners, lawyer Charles Kanjama took issue with the government entities questioning to what extent the courts had a reach in determining the legality of any business transacted within the confines of the law.
Anything that is inconsistent with the Constitution, any law, is void to the extent of that inconsistency. And this can be read together with Article 165 that deals with the power of the High Court and therefore the Court of Appeal and Supreme Court, and says that the court has the power to determine whether anything said to be done under the authority of the Constitution is null and void. So if something is null and void, it cannot be subjected to structural interdict. It cannot be subjected to a mechanism of nursing it into life. It is void for all purposes.
The judgment of the petition, as communicated by Chief Justice Martha Koome, will be on notice. Alan Wino for K24.